Thank you very much, Justice. It's so good to see you. Donald, thank you for inviting me back to the George Mason Law and Economics Center program for judges. It's always an honor to speak with you. I wish we had more of a chance for dialogue, and hopefully later today so I can learn from you as well. But I always am impressed by your dedication and to come here and to learn. You know, it's interesting, when I was thinking about this topic today, I'll call it nuclear verdicts. I know it's a bit of a loaded label that we attach to it. You can call it gigantic, extraordinary verdicts, however you want to call it. You know, I was just trying to think from my perspective, I've been out of law school for about 30 years now, and I was trying to think of, like, I never really experienced what would today be considered a nuclear verdict at any point in my practice as a young lawyer, which started off doing a lot of automotive product liability litigation. I was doing work then coming out of law school for Jeep Chrysler and rollover litigation and the old CJ. And I remember if we had a truly catastrophic accident, you'd be talking about $1 million, $2 million would be considered a huge award then. Maybe it just shows how old I am. But, I mean, it kind of, you know, when I was thinking, the only thing that I could think of as truly enormous earlier in my career was the Exxon Valdez verdict, which really made national news, you know, because there you have really destruction of a massive part of the Alaskan coast with impacts on fishermen and the environment and so forth. That award was $5 billion, later reduced to $2.5 billion in 2006. So 2006, you know, our sort of marker for what was extraordinary was $2.5 billion, really for destruction of an entire coastline of a major state. In the last month, there was a verdict in Massachusetts. Unfortunately, one of my partners was on the receiving end of this in a smoking-related health lawsuit. $8 billion to a 60-year-old former smoker in punitives and $1 million in compensatories. A month ago, Ford Motor lost a case down in Brett State of Georgia, $1.7 billion in punitive damages, $24 million in compensatory damages to two people, you know, unfortunately, who were killed in a rollover and a roof crush incident. And I don't intend at all to minimize the injuries to these folks. And where people are injured due to somebody else's fault, they should be paid. But when you're talking about $1.8 billion, that's not adequate or reasonable compensation by any stretch of the measure. You know, going back in a little bit more recent history, some other big verdicts. Missouri, $4.4 billion in punitives and $550 million more in compensatory damages to 22 women who allege ovarian cancer from talc exposure, later reduced to $2.1 billion. Huge verdict. But those are also cases where the company was winning probably most of the cases, either on summary judgment or on jury verdicts in other cases. I've had some experience with the Roundup litigation. In California, one of the cases, $2 billion in punitives, $55 million in compensatories, in a Roundup case, later reduced to $90 million. In three cases that first went to trial, the reduced verdicts came to $90 million, roughly $80 million, and $25 million. Contrast that with the last 5 cases that have gone to verdict that have all been defense verdicts. There's something very unpredictable and crazy that's happening in certain jurisdictions of America. And the U.S. Chamber, today I'm not going to throw a whole lot of data, and I want to move on to the other panelists so we can get into a discussion about what's going on, why is this happening, what are some things that, if we should do something about it, what are those factors? And I'm just going to, as the Justice pointed out, in the readings you'll see a new report that just came out last month from the U.S. Chamber Institute for Legal Reform, done by my colleagues Carrie Silverman and Chris Appel. You saw Chris earlier today talking about the class actions. But in this research, they looked at
about roughly 1,400 nuclear verdicts, and defined as a verdict of $10 million or more between 2000 and 2019. That alone was astounding to me, that in that 9-year period, we had 1,400 verdicts above $10 million in the United States. And what they found in looking at the data is that the awards, those big awards, are not only happening more frequently, but they're becoming more severe. So they looked first at awards above 10 million to 20 million. That was about half of the nuclear verdicts in that 10 to 20 million dollar range. But over the last 10 years, that number is moving from closer to the 10 up to the 20 range. Verdicts up about 30%, way outpacing inflation in the last decade. What types of cases are we seeing this in? Roughly a quarter of them are product liability cases. Another quarter are medical negligence cases, and within that, nursing home deaths and infant injuries are the vast bulk of the big cases. And then roughly a quarter of them are auto accident, and a large percentage of those are trucking accident cases. And then the other 25% or so is sort of a random mix of some intentional torts and bad faith cases and things like that. But we're really looking at catastrophic personal injury cases that are driving this issue. 10 states accounted for 3/4 of the verdicts. Many of these are explained by the population of the state, right? So you look over the list, Hawaii's not on the list, either in terms of the severity or the population. But you've got Florida, California, New York, Texas, as you might expect. But even within those, the severity of the verdicts and the size is not justified or explained simply by the population of the state. There is something happening in these states that goes beyond just the fact that they have a lot of people. And the thing that also surprised me, because I would have thought that the big numbers would really be driven through these punitive damages awards, like this case in Massachusetts a couple weeks ago that was, $8 billion to a smoker, but virtually 99.9% of it was driven by punitive damages. These big verdicts, these 10 million plus verdicts, are really driven both by non-economic damages and punitive damages. When you look at what's driving the large awards, the non-economic damages component has as much to do with it as the punitive damages. And I think that, I'll just sort of wrap this intro up, I think that is probably being driven because of the changes over the last 20 or so years at the Supreme Court in many of your states, where the Supreme Court of the United States has issued a number of opinions putting guideposts on punitive damages, and saying things that like single digits, generally an award should not exceed the single digits. Many states have caps on punitive damages or have enacted higher burdens of proof on punitives. And I think as punitive damages run wild, I think that was the quote that Justice O'Connor said in the L.L.P case. She talked about run wild punitive damages. As that has been corralled, the plaintiff's bar has looked more to non-economic damages as a driver for profitability. And so that's sort of where we are with the data, and now we'd like to have a discussion about what may be driving that.
All right, thanks. Thanks a lot, Mark. Right, and so I assume like the Ford 1.7 billion punitive with compared to 24 million of compensatory damages has been or will be reduced based on the United States Supreme Court precedent.
Yeah, that's a very good question, because the data reflects verdicts and not what later happened 4 or 5 years down the road. Many of these probably are overturned or reduced on appeal. But what the public reads is the headline, right? That's what's affecting jurors when they go into jury boxes, these other verdicts that they've read recently in the news.
All right, well, let's turn now to Brett, and she can tell us more about her experience in these types of cases and what she thinks is going on leading to these types of verdicts.
Yes, so I'm only 9 years out of law school, and I have been a part of 15 different trials, many of which were tobacco. So one way to get thick skin as a young lawyer is to be a tobacco lawyer, where they're calling you a merchant of death in the courtroom. And I have seen several verdicts that were 21 million, 150 million, 14 million, several cases. And then we also have several defense verdicts. So there's interesting things that are going on. And these are tactics that I've seen in the courtroom. I've been part of trials in Georgia, Florida, Massachusetts, California, the U.S. Virgin Islands, Superior Court of the Virgin Islands, a very interesting place to try a case. And you see these tactics, and speaking of the $1.7 billion verdict in the Georgia case, I found it fascinating. There is a legal newspaper, the Daily Report, that comes out in Atlanta, and knowing I was going to be on this panel, an article caught my eye about that verdict, and they highlighted that in the first portion of the closing argument, the plaintiff's lawyers stressed the contentious nature of the litigation that had gone on for nearly 8 years, saying, why won't Ford do the right thing? They fight and they fight, they try to wear folks down. Now, I'm a defense lawyer, I always have been, so my perspective comes from there. But whether or not a defendant actually chooses to contest liability and damages in the courtroom should not be a reason for a jury to award damages. Defendants have the right under the law, just like anyone else, to contest the liability and the damages. And so that, to me, is an example of improper argument that's being made, that's inflaming juries, and they're being told that this defendant contested the case, and simply because of that, they should be punished or they should have damages against them. As a tobacco lawyer, there is an entire just wealth of tobacco precedent in the state of Florida because of all the Engle progeny litigation. And that is a tactic that courts in Florida at least have said, you can't do that. You can't disparage the defendant for simply contesting liability and damages. That is their right under the law. But here we have it in the beginning of the plaintiff's closing argument where a $1.7 billion verdict was given. Another tactic that you see is making a claim that the defendant never apologized or took responsibility. This is something, there was another big verdict in Georgia. It was a $100 million verdict against the city of Atlanta. It got overshadowed by the $1.7 billion verdict that happened a few days later. And that was part of the argument, again, that was reported in the newspaper. The plaintiff's lawyers argued they never took responsibility or apologized. Defendants can contest liability and damages, and those are just two examples of jury arguments that are being made in these cases where we see these nuclear verdicts that have nothing to do with, was there a duty that was breached that then caused the plaintiff's injuries? Even if there's punitive damages at play, which there always are in these large cases, those types of arguments need to be carefully governed by you to make sure that the jury really is making their determination on what the law is requiring them to determine, not whether or not the defendant was, taking responsibility and apologizing to the family. That, again, has nothing to do with whether or not the product was defective and actually injured the person in this case. A similar tactic that I've also seen is criticizing the defense for not bringing a corporate representative. If there's no affirmative defenses in the case, the defendant has no burden. They don't have to bring anyone. They don't have to bring a single witness. So again, that goes to trying to criticize a corporate defendant, especially by saying, well, they don't care about the case. They don't care about this family. They didn't even bring anyone to this courtroom to talk to you about it. All of these we see in these cases that then result in these high verdicts. And even if we're not all defense biased, like I know that I am, I think we can agree, again, those arguments have nothing to do with the actual legal issues at play. So those are some of the things that we're seeing that do connect to those really high verdicts. And I think you have to be a good lawyer representing your client. Make sure you file the motion in limine on those issues. You educate your judge that this is a type of argument that might be made, and it might happen very quickly in closing. Well, we all know making objections can be difficult. We want to try not to make a lot of objections during the closing argument. That's a really important time for the jury, and you don't want to be seen as an obstructionist lawyer. But the fact that these articles are coming out showing us these types of arguments are being made and they're connected to these very high verdicts, that speaks something to me about what proper or improper arguments are influencing juries. One other thing that I was asked to talk about, because I am a millennial, is the rise of millennial jurors, which has so many lawyers shaking in their boots. Just to talk a little bit about the millennial generation, of which I am one, they are now ages 27 to 41. So if you've got a college student, that's not a millennial, that's a Gen Z. That's a different type of generation. But having millennials on juries, I actually think is a great thing. Again, I am a millennial, so I don't believe a lot of the negative stereotypes about our generation. They do have high expectations for doing the right thing. Now, that means they can hold people like my clients, corporations, to a higher standard than maybe the law necessarily requires, because they have in their own minds what is the right thing. But I think that makes them good jurors, and they are looking to the judge to tell them what is the right thing to do in the courtroom. Here's what the law is requiring, and we expect you to follow it. And I have found that jurors, millennial jurors, can follow that, even though there is some data out there that says they do believe in jury nullification, even if they're told the law requires them to do something, but they want to do the right thing outside of that. I think their drive to do the right thing means they will listen to the court, they will listen to what the court tells them to do, and they're really looking for what's the truth, what happened here, and how can I make sure I'm doing the right thing and following what the judge has instructed me to do. They are the most highly educated generation to date. I had a trial in the Central District of California in September, so just last month, and we had 3 millennial jurors. There was a PhD in software engineering, there was a nurse practitioner, and there was a lawyer. They were very educated, they took notes, they paid close attention, and we were able to talk with the jurors after the trial, which we did get a defense verdict, so we were rather pleased to speak with them on their thoughts. And they did pay very close attention to things that you would think the tech-savvy generation will look at. They thought the visuals were very important. They noticed when counsel was not being organized, didn't have the right materials with the slides, and things were taking a while. I think all jurors now, the CSI effect, are expecting us to just be extremely polished and presentable. But the millennial jurors, they were kind of annoyed with the lawyers, not on our team, that were struggling, that were not organized, that seemed were kind of wasting their time in the courtroom. So I thought that was a really interesting perspective from them. The other thing I'll say is that they did work well with other generations. And Adrienne and I were just kind of talking a little bit about juries, and one of the things that we're thinking about is how jurors of different generations are going to work together. Although millennials have been labeled as entitled and narcissistic and overly confident in their abilities, I do think most of us work well with baby boomers because that's our parents. And I respect my parents, and I have great conversations with them about different thoughts and topics. And so this last trial that I just did, our foreperson was a baby boomer, and her best friend on the jury was the millennial lawyer who was sitting next to her. And we could... You watched jurors during a trial, and you could tell they were kind of talking. They would check in with each other if the court asked for the jury to stay a little bit later. They would look at each other, or do you want to stay, do you not? And she was our foreperson, and we know he was a big advocate for us in the jury room. So I do think millennial jurors is not something we should be afraid of. Any of us, especially from the court perspective, I do think that they're going to listen and be instructed on the law and try to follow it, because that is a big characteristic of their generation. So those were my points for today, and I appreciate talking with all of you.
That's really interesting, yeah, especially with the millennial jurors. In terms of expressions of sympathy, apologies, we actually in Hawaii have a rule of evidence that says expressions of sympathy and condolence is not admissible to show, to prove liability. But if there's an apology that is an admission of liability, then that could be admissible. Now, I'm wondering, by the same token, you reminded me of a jury trial I had in which the defense actually presented evidence that, the defendant had actually gone to the hospital to see the plaintiff after the auto accident, just to make sure that the plaintiff was doing okay. Do you think that should be admissible? What do you think?
Again, it goes towards what are the legal questions that the jury has to answer. And I obviously pointed out some of the tactics that I think plaintiffs are using to really criticize corporate defendants. But there are things that we are kept from doing in the courtroom as well. We can't talk about the fact that if there's a big verdict, a lot of hardworking, good Americans might lose their job because the company has now taken a huge $2 billion, $7 billion hit. We can't talk about the company is staffed by, great people who are really trying and really we're not allowed to bring in that type of evidence that really has nothing to do with, was this product effective? Did it actually cause the injury? And that type of evidence, I just don't think really goes to those legal questions. Again, it can have some relevance to the punitive damages, which is why maybe bifurcation can be helpful if you need to kind of separate out those issues. But if I were a plaintiff's attorney, I would certainly file a motion in limine to say whether or not the defendant came to the hospital later to express sympathy is not something that I would want to go in front of the jury, because it doesn't have anything to do with whether or not that defendant was negligent in driving the car and caused an accident that caused the injury.
Very good point. Okay, thank you. So finally, we'll now hear from Professor Lerner, and please proceed.
It's a pleasure to be here and to speak with so many judges about the jury. And like my co-panelist, I think I'm hoping to learn things from you all as well. The jury is my specialty, and I think about the jury from both a historical and a comparative point of view. I have a book coming out, hopefully, fingers crossed, in January of 2023 with Oxford University Press, and it's called The Jury. It's part of their very short introduction series. And I discuss the jury throughout history and around the world. And we just had a discussion about Athenian juries, and I cover those as well. And there's a flyer out on a table in the lobby about the book, if you're interested. Among other things, I discuss civil damages in the United States. So I do get to that. As Justice McKenna mentioned, I wrote an article about Montesquieu and Tocqueville and their view of juries. And there are copies of that, again, out in the lobby if you want to take a look. Both Montesquieu and Tocqueville were celebrated political philosophers, both heavily influenced Americans, but there may be something that you don't know about them, and that is that they were both judges. And so when they wrote about judging and juries, they had some basis of experience on which to go. Both of them, now they're both French judges, of course. They weren't American judges, and France at that time did not use lay jurors, certainly in civil cases, and lived to a limited extent in criminal. But both supported the use of lay jurors. They thought that that was a good idea. But it's very important to note that they attached a condition, a vital condition. They said juries only work if the judge provides firm guidance. And here's what Tocqueville had to say about that. He said, in civil cases, the judge, and I'm quoting him here, unravels the various arguments the jurors are finding so hard to remember and takes them by the hand to guide them through procedural intricacies. So that was his view, and you all know that that does not always happen in American courtrooms today. But Tocqueville and Montesquieu both considered it vital to maintain the jury system for the judge to provide this very firm guidance. So I'm going to talk about judicial guidance to juries, especially in the area of damages. As you probably know, multiple studies have shown that the area of greatest disagreement between judges and juries is in the area of damages. Not so much on the question of liability, but on damages. And unpredictability is a big problem, as Mark was talking about. A 2016 survey of trial lawyers showed that, in their view, the top reason why they settled rather than go to jury trial was unpredictability of damages. Jurors do tend toward certain beliefs or biases, not all jurors, but many, that I'm sure are known to you all. And this has been shown in multiple studies. They do tend to favor individual litigants, and they tend to be disinclined to favor corporations, and especially insurance companies. Jurors, unlike you all, jurors do not face direct accountability for what they do, so for the damages that they award. You all, if you're a trial court, of course, you face appeals, and if you're an appellate judge, you have to write the opinion and explain what you've decided. Jurors do not face that. They are giving away other people's money, essentially, without accountability. And to highlight that, there was a tweet by an Arkansas juror in a civil case in 2009, and the juror tweeted, "I just gave away $12 million of someone else's money." And $12 million was in all caps. So they were very pleased about that. Jurors often have trouble understanding instructions on damages. Again, there are many studies about this, but I'm going to give two examples. Now, neither of these examples is a nuclear verdict, right? They aren't in the millions or tens of millions or hundreds of millions or billions of dollars, but they are instructive about how jurors can misunderstand what their job is, essentially. And one of them is from Cook County. And I know we have a judge from Cook County, Illinois here, and there may be others that I haven't met. But in any event, so this is from your home turf. And I talked to a juror in a case who was an accountant. So someone very comfortable with numbers, a professional, a quite intelligent person. And he had served on a jury where the plaintiff had earlier been acquitted of a murder. And he was suing the city of Chicago for holding him without probable cause, he said, for 2 years prior to trial. The jurors, when they went into deliberations, they decided that the city was liable. They thought that they were supposed to determine damages based on an average person. Several of the jurors were professionals, like the accountant I talked with. And so they used themselves as an example of what is an average person. And so they were calculating their loss for 2 years being in prison. At the time of his arrest, though, the plaintiff was on probation and unemployed, and probably unemployable because he was a heavy drug user. And of course, the jurors were supposed to determine it based on that specific plaintiff. But they didn't understand that. So they came into the courtroom with their verdict and their amount of damages. And the judge was, as the juror said, visibly annoyed with them and basically told them that they got it wrong. Now, the juror I talked to, like I said, was a reasonably intelligent person, but he and the other jurors had missed what they were supposed to do. So that is what can happen. I'm sure the instructions were correct, but they somehow missed it, even though they brought written instructions with them back to the jury room. Another example I have is from a plaintiff's lawyer in Iowa. And this lawyer told me that he was representing a plaintiff in a medical malpractice case, and the injuries were relatively mild, he said. In terms of the cases he normally handled, it wasn't that severe. The jury came back with a verdict for the plaintiff for $681,000. Everyone was surprised at that verdict. The judge knocked it down to $600,000 on remittitor, but that was still much higher than anyone expected. After the trial, the lawyer talked with the jurors, and the jurors said that the jury had determined, kind of the day before they gave the verdict, that the defendant was liable, but it was late in the afternoon and they didn't want to deal with the question of damages. So they put that off to the next morning. The next morning they came in and the foreman asked the jury, well, does anyone have any ideas about what the damages should be? And one juror said, yes, I had a dream last night. And the damages in my dream were $681,000. And the foreman looked around at the other jurors and said, well, does anybody have any other ideas? And nobody did. And so that was the verdict. So you can see there can be some problems here. And one is that the jury might have, and often does have, difficulty following instructions. And the other is that a strong leader on the jury can have a huge impact, even if that leader may be misguided. So these are some reasons why juries are in need of strong and clear guidance from judges. The English have developed an interesting way to do this. Now, in England, they have essentially abandoned civil jury trial. All of their civil cases, for all intents and purposes, go to judges, except for defamation. But their criminal cases still go to jury trial. And the English judges have developed something they call a route to verdict, which is, in effect, a decision tree. And the judges themselves have to write the decision tree, and they write it out, and they give it to the counsel before they give it to the jury, and counsel can make comments, but it's within the judge's discretion whether or not they make edits to their decision tree, to the route to verdict as a result. It seems to me and English judges have given me these things, and they're available online. You can check online for the English route to verdict and take a look at them. I have been very impressed with them. They are extremely clear. They are written in very plain English, which unfortunately is not always the case with American jury instructions, with American pattern instructions. They are tailored to the specific case, so there's not too much confusion in jurors' minds about what applies to what. And it seems to me that judges could apply this method to civil cases as well and walk the jury through the different damage calculations and how to do it, and provide lines on the verdict form for these different calculations. And that seems to me it's not too far different from our what can be a typical verdict form in the U.S., where you have the general verdict and then interrogatories after that. And so I don't think that's too much of a stretch to go from that to the English route to verdict. The English judges do include with their route to verdict a written summary of the evidence, which they are required to do to guide the jury. And I fully understand that American appellate judges are reluctant to allow trial judges to do that. But in our history in America, we do have a strong history of judges summing up evidence. And that power, unfortunately, has been lost over time. But American judges did used to do that. So adopting this technique, I think it's fair to say, would require some adjustment to our normal, very tenacious adversarial mindset. The trial judges would have to write these decision trees, and the appellate judges would have to give the trial judges a little bit of leeway in writing them and not be terrified about every word that a trial judge uses, which is sometimes the case with jury instructions. This effort, though, seems worth it. I think it would be a good thing if judges adopted a bit more, American judges at least, adopted a bit more of an attitude that they were responsible for the correctness of the outcome. I know that this is a shift in mindset to some extent, particularly when American judges are dealing with juries. I recall what an English judge said to me once, and we were talking about the differences between English judges and American judges. And she said, well, the difference is that our judges are judges and your judges are referees. That's what she said. I mean, of course, a judge can always use remediator or additor if necessary. Sometimes that's necessary too. Sometimes juries are too stingy. But rarely, I think it's fair to say, does an American judge bring the amount of damages to the legally appropriate amount. So I think it would be better to try to give the jury crystal clear guidance before the question goes to them. Thanks.
Very interesting and such fascinating thoughts. You know, in her article, she mentions the trial of William Penn and Mead in Old Bailey in England, the criminal courtroom in London. And I think one of the big differences is at least traditionally in England, and it appears even now, the judges would basically tell the juries how to rule, like sum everything up and tell them what decision they really needed to reach. And of course, William Penn and Mead were found not guilty, jury nullification, because they had clearly violated the law at that time in terms of espousing their religious beliefs instead of the Church of England's. And they were found guilty, but the jury found them not guilty, and then the judge imposed fines on the jurors. One refused to pay the fine, and then he challenged that, and then the decision was written saying that the jurors, basically the right to jury nullification, the juries don't have to follow what the judge says. But I'm really wondering, because we have a rule, Rule 1102 of our Hawaii Rules of Evidence, which clearly says that the judges cannot comment on the law. And so any instructions from our perspective, at least statutorily, it would have to be through the jury instructions and or what we call the special verdict forms, the interrogatory verdict forms. I'm wondering how many of you are from jurisdictions that clearly judges cannot comment on the law? I'm sorry, on the facts of the case, on the evidence. I'm so sorry, that cannot say cannot do what the professor suggested, like this is how you view the damages, this is how you analyze the damages. Can you raise your hands? Okay, yeah. So it seems like in general, the United States now, that has been the trend, and we've given that power to the juries, and the civil jury, and apparently even Alexander Hamilton, as you say, thought that the judges would be able to control the juries a little bit more. So that I do find that quite interesting. So we've had a lot of discussion from our three experts about the issue, what might be leading to the issue, and suggested approaches. But I think there may be other issues other factors you think that may be leading to some of these verdicts. And if you could talk about some of those other factors, as well as what you think the approaches from the courts could be on some of those issues. And you might want to comment on what each other said too. So Mark, go ahead.
Okay, I'll give you three really fast. When I first started off my first firm, Mr. Kroll and Mooring, Mr. Kroll said, keep it to three. So if I can remember the three here. One is anchoring tactics. One of the things that is driving the increasingly severe awards is something called plaintiff anchoring, which is simply a tactic where the plaintiff attorney, typically in closing arguments, throws out a number, and it's often an arbitrary number about how much the jury should award in non-economic damages. And the reason they call that an anchor is that when we're talking about pain and suffering in particular, there's no market for pain and suffering. We don't really have an idea of what the value of a lost limb might be. And so when the attorney throws out a number, $25 million, $5 million, the jury grabs a hold of that. And that sort of becomes the number that anchors their decision. They may ratchet it up a little bit more if they think the plaintiff has a stronger case, or ratchet it down a bit if they think the plaintiff's case is weaker. But that's the baseline that they're using. And there are a number of articles that have come out in recent years by plaintiff jury consultants that literally say the more you ask for, the more you're going to get. Because if you ask for $30 million, the jury may say, that's crazy, that's way too much. We'll just give them 15. We'll cut it in half. We'll give them 15. And in the minds of the jury, they're really cutting that award down. And yet that award is still much, much higher than what the historical values might have been. And the plaintiff's lawyers have figured this out. Or oftentimes they'll tie it to something like award, we saw this in one of the first roundup cases, award $1 million in a year in pain and suffering, and then multiply that by the plaintiff's life expectancy, 37 years. That's what the pain and suffering award came out to, almost exactly that amount. So it's working. They've figured this out. And again, it's probably to deal with, some constraints on punitive damages. One thing to do about that, it should be, I think, And ALEC, the state legislators group, has a bill that says Anchors Away Act, which is to say don't let people make anchoring arguments on either side, plaintiff or defendant. Let the jury hear the evidence and from their own personal experience figure out what is the appropriate amount without being manipulated into a number by the attorneys. The other thing is something that we call in the civil justice reform community phantom damages. This is when the jury is presented with medical expenses that are the billed amount by the doctor rather than the amount the plaintiff actually paid. So I've got 4 little kids, and there's one of them going to a pediatrician. My wife called me this morning. I got to take our boy to the pediatrician. So every week I get these statements from BCBS, Blue Cross Blue Shield, about, and you get them too. If you look at it, it'll say, pediatrician visit, $350, billed amount, $350. Then minus, negotiated discounts, group discounts, minus write-offs from the doctor, amount you owe, $25. So in many courtrooms, the jury is told that the plaintiff's damages are $350, but they're not. They only paid $25. So what you get are medical expenses that are way out of proportion to the actual harm that the plaintiff suffered. And there are a number of states that are working on that, reducing that ability for plaintiffs to throw out numbers that we call them phantom damages because nobody actually paid it. Those are a couple of ideas. And then the other is in the trucking cases and the car accident cases is seatbelt admissibility. In most places, the jury cannot be told if the plaintiff was not wearing a seatbelt when the injury occurred. That really is an obsolete relic from when seatbelts first came into cars in the, say, 60s and early 70s, and nobody wore their seatbelts in those days. And so the feeling was we can't penalize plaintiffs for something that they didn't do because nobody was doing it at the time. Our culture has changed completely since then. Most people, the vast majority of people do. First thing they do when they get in the car today is put on that seatbelt. You put an infant in the back, you put on that seatbelt. So our culture has changed, but the law has not kept up with the change in culture. And, and talking to automotive defendants, they tell me in probably the vast majority of their cases, the plaintiff is an unbelted plaintiff in their case. And it certainly exacerbates the damages. Why aren't juries being told about it? They're being blindfolded. They can't make informed decisions about the harm when they're not being told simple facts in the case.
I do find that last point really interesting. I don't think we've really dealt with it in Hawaii, but it seems to me our law is pretty clear. Violation of a law can be evidence of negligence, and so therefore it seems to me that a seatbelt failure to wear a seatbelt could be evidence of comparative negligence and/or failure to mitigate damages, possibly. But I'm just curious, how many of you are from states that would not allow evidence of us not wearing a seatbelt? Very, very interesting. Thank you. That's quite interesting. One thing, obviously, the collateral source rule, that would require some judicial or statutory changes. In terms of the anchoring arguments, it seems there might be some legal things that might, legal changes that might be required. But one of the things that, we in our pre-discussions was mentioned that on the defense sometimes has a reluctance to give an anchoring, give a suggested damages on the grounds that it might be considered like an admission of liability. In my experience in all the civil jury trials that I presided over, the defense always said, you know what, we're not admitting, we do not think we're not liable, but you may reach the issue of damages, so therefore we suggest that the reasonable amount of damages is this, and is a much lower amount, a very low amount, in fact, usually. And in all of my cases except one, the jury came back much closer to the defense, sometimes even under what the defense had suggested. So it seems to me in the meantime, it would make sense for the defense to argue, at least argue damages without conceding liability. Brett?
And yeah, I'd love to speak on that. I think whether or not the defendant is going to anchor with a smaller number is a very intense strategic question that the team is thinking about the entire trial, because you might want to throw that number out to try to counter the 50 million. But if the jury was already going to go to 50 million and you say 500,000, they might be so offended that you would give this smaller number that you've now inflamed them even more. So I know we've only done anchoring in one trial that I've been in, and it was a very, very fraught decision. Lots of discussions with the client on whether or not we were going to anchor, because it could really have a backlash. You even see now, one of the things I was thinking about when Mark was talking about the anchoring and throwing out the really big numbers, I had several cases where the plaintiffs wouldn't even put in their evidence and would drop their economic claim because they didn't want the jury to see the number of medical expenses and that it was only $400,000. They didn't want the jury to even be thinking about the $400,000 number. They wanted them to be thinking about the 50 million pain and suffering number. So now that's another tactic where they'll just completely drop the economic damages in a way to keep the jury focused on the much bigger number, which the case law has said is it's up to the enlightened conscience of the jury. The trial that I just had in September, we got a defense verdict, thankfully, but the plaintiff's lawyers did ask for $50 million for the pain and suffering. And the way that they did that was they said that the plaintiff was experiencing, maybe she wasn't in pain all day long, but she was in pain 12 hours out of the day. And she's going to live 16 more years based on the mortality tables. Why don't you just give her what corporate defendant pays their experts, $600 an hour for 12 hours a day for the rest of her life? That's $45 million, and let's give it another $5 million for her husband for loss of consortium. That was the number. And so these are the types of things that juries are hearing. They don't know how to calculate. And so when they hear that, if they're already leaning towards liability, it sort of reasonably makes sense to them and it's logical to them, but I'm not sure how we counteract that. I do think it's interesting in Massachusetts, if you, as a plaintiff's lawyer, want to put a number in front of the jury during closing argument, you have to disclose it to the defendants the night before. So there's a little bit of time that the corporate defendant then has some time to think about, okay, they're going to ask the jury for $50 million. So do we want to anchor? How are we going to counter that? I've only ever seen that in Massachusetts. Yeah. Other states, you just wait. You're waiting on pins and needles during closing argument to see how much they're going to throw out there and ask for. So I do think that there are ways to help control it. I like that in Massachusetts you have a little bit of advance time to think about what number they're going to ask for. So that's potentially something that could be done in other jurisdictions to try to create a little more balance during the closing argument. But all of these are big strategic questions that trial lawyers are pondering the entire trial.
Very interesting, a different perspective. Professor Lerner, you had talked about the route to verdict, and it seems from Hawaii's perspective, that would be more the special verdict form. And it's also, I'm wondering, you probably have additional thoughts based on what everyone has said, but my question to you would be, right now, our general civil special verdict forms just says, plaintiff, was the defendant negligent, proximate cause, plaintiff contributorily negligent, proximate cause. This is just regular negligence case. And then damages, and then what is the allocation of liability if both the plaintiff and defendant were negligent. And we're modified comparative negligence state. So if the plaintiff is more than 50% negligent, they don't recover anything. But our damages, we only have general, which is for the pain and suffering, emotional distress, and special. Do you think we should, our special verdict form should actually perhaps, our verdict form should be a little bit more clear in terms of the amount, the types of damages that are being suggested?
Yeah, exactly. It should be broken down into the different types of damages. So lay it all out there. And also with instructions about how to calculate them. And of course, there's still a lot within the jury's discretion, exactly what amount they find and so forth. But I think with that kind of guidance, it will be better for the jurors. They will be less confused and most importantly, less swayed by the partisan arguments of the lawyers. This is the problem, that with those prohibitions on the judge commenting on evidence or giving more specific guidance on the law, essentially you're leaving the jury at the mercy of opposing counsel. And neither one of them necessarily is on the side of truth and light, with all due respect to my co-panelists here. And the judge is the person who really can provide that experience and impartial view that you're not getting necessarily from either of the lawyers. So I think that is very important. And this more specific guidance, as we were talking about, with respect to the different components of damages and how to calculate them, would be very important. I would just say, on a historical note, I've studied the loss of the judge's power to comment on evidence in the United States, and it was an interesting story. A story that I think may not be too surprising to some of you. So the biggest people pushing to limit the judge's ability to comment on evidence were lawyers. Because the lawyers want to be able to run the show themselves, right, without interference from that annoying judge, right? And so that's what happened in some of the state legislatures. And then there was another, so that many of them, that's what happened. In others, there was an interesting story too, which is that still today, a number of states do allow, in theory, judges to comment on evidence, and the federal courts as well. That's still allowed in theory. But in practice, the appellate courts have clamped down so hard on the trial court's ability to do that, that in practice, no trial court does today. And so that's an area where it wouldn't even require necessarily legislative intervention, where the judiciary themselves could decide, maybe it's not a bad idea to have the judges sum up the evidence the way they do in England and are required to do in England. But regardless of the judge's ability to comment on evidence, there's still the possibility of getting better guidance on the law.
Thank you. Such great, wonderful thoughts. Does anyone have any questions or comments? Yes. Perhaps you could go to the mic? Yeah, thanks.
Professor Lerner, I'm a little surprised on your advocacy for judges commenting on the case, particularly on the facts of the case, because it seems to me this is it would create an error factory. I mean, it's sort of be careful what you wish for, because it's one thing for you folks to sit up there and say, let's have judges reining these things in by commenting more on the merits of a case. In the abstract, you may think you like that, but you're going to stop liking that when the judges give a summary that doesn't suit your view of the case. So I would say be careful what you wish for. And from my perspective, that suggestion is rife with the potential for mischief, for all kinds of error. We see it when judges even stray from the suggested standard instructions, which are in our state not prepared by the court, but they're suggested standard instructions for a reason, that they're pretty much going to keep you out of trouble. And when judges freelance on those, that's when we see some appeal. So I guess maybe if you could react to that, that would be terrific. And I just want to say one thing, is that one of my table colleagues is a high court justice in Maryland. And when you were talking about judges commenting on the merits of a case, I was reminded the only time in United States history when a United States Supreme Court justice was impeached was Samuel Chase in the early 1800s, and he was lambasting juries and telling them what he thought of cases. So perhaps you could. He was not removed by the Senate, but he was impeached by the House.
And she does mention that in her article. Yeah.
Yeah. I hadn't forgotten about good old Justice Chase. But there is, of course, this is the problem that appellate courts have been concerned about, that the judge will be biased. That's the issue. And I will say this, that the appellate judges in this country started to be more and more concerned about comment on evidence as judicial elections spread. So as that system took hold. So I will simply say that. But that being said, I hope that the judiciary of this country is still relatively impartial. And the difficulty is that when you look at it from the trial judge point of view, American trial judges are very worried about being reversed on appeal, right? That's kind of one of their main concerns. And so you adopt the pattern instructions and you read them very carefully and you submit them to the jury and all that kind of business. The difficulty is that the jurors in many cases do not understand them. And so you get injustices because they do not understand what the jurors are supposed to be doing. So I think, in other countries, they've managed to loosen up a little bit. In England, they do have a system where the judges do this. Now, we don't have to necessarily go so far as to say that the judge can comment on evidence. The English judges technically don't comment on evidence. They sum up the evidence, which they regard as different. But they have a system where it works, where the judges do sum up the evidence and the appellate judges don't always come down on them and say, no, new trial. So if they can do it, I suspect we can too, at least in some states. We both have adversarial systems, and I suspect that it could work here. And that I think the judiciary of this country needs to not be so terrified of a trial judge saying the wrong thing when jurors are routinely completely baffled by what their job is.
I think our time is up. All right, our time is up. So for those of you who are really interested in additional discussions, please come up and discuss it with our learned panelists. Thank you so much, everyone. Really interesting discussions. Thank you.